probably know about YLAL, if I can just very quickly tell you about them, or us, so you know if you're not aware or you're not signed up. So we have 3 aims: to campaign for a sustainable legal aid system, offering good quality legal help, to promote the interests of junior lawyers and those that wish to become legal aid lawyers, including focusing on social mobility and diversity in the legal aid sector, and to provide also a network for like-minded people at the start and early stages of their career. Now, if you're not a member already, you can sign up for free. Our website is youngleadlaidlawyers.org, and there's various ways to get involved. We offer a really successful mentoring scheme, and so if you're a student or someone seeking either a training contract or pupillage, you can be paired with a junior lawyer who offers you assistance. And we also regularly have the opportunities for our volunteers to help with the work that we do. So please get involved and sign up for free if you haven't already. Now, tonight we're going to look at the particular challenges faced by asylum seekers and refugees who are trying to access justice during this current pandemic. Now, we have 3 brilliant speakers. I'll tell you a bit more about each of them just before they address you. But it's Dr. Chelvan from number 5 Chambers, Ali Bandegani from Garden Court Chambers, and Philip Armitage from Duncan Lewis, are all specialists in this area. And so we're really happy to have them with us. Now, in terms of structure, each of them is going to talk to you for about 15 to 20 minutes on a certain topic. So Philip's going to talk about the recent litigation by Detention action about protecting people from COVID. Ali is going to talk about socio-economic rights and how COVID has impacted on that. And finally, Chelvan's going to talk really about practically how this time can be used to prepare cases better and more thoroughly, waiting for the hearing. In terms of how Zoom works, there's a gallery view if you want to see more than one person. And just before we start, please join us on social media. If you want to tweet about the event, the hashtag is YLAL virtual, and that means you can join in the discussions now or later. Any questions, we're going to take questions at the end, but if you ask them in the chat box, I'll be picking those up, and at the end we'll try and go through a few questions with our speakers. And in terms of thank yous, we'll come to those at the end, but obviously to our 3 speakers for joining us and giving up their evenings, and to the 36 group for hosting this meeting on their Zoom platform. And so first of all, we're going to talk to Philip Armitage. And so I'm going to ask Philip to unmute himself and put his camera on. Excellent. Hi, Phil.
Hi, you're right.
Good, thank you. So you're a solicitor at Duncan Lewis, and you specialise in public law and immigration, caseload involving challenges to the Home Office policies, asylum applications and unlawful detention claims. And Phil, you're going to tell us about your recent case on behalf of Detention Action.
Yes.
Okay, I'll leave it with you then. Thank you.
All right. Perfect. Well, thanks for the invite. I'm just going to put there's a few documents I'm going to put on the chat, which is I might refer to, but just so everyone has them for your reference. But yeah, what I thought I'd do is talk about the recent detention action case challenging the Home Office's policy of detaining people during the COVID pandemic. So I thought I'd start by a few issues about why it's a problem to detain individuals during the COVID pandemic, then talk about the detention action case itself, and show that even though detention action were lost that case, there was actually quite a few victories that you can get to, and quite a lot of stuff that people can use in unlawful detention cases from that litigation, and even from the judgment. And also then to cover just a few practical steps about how you might challenge a client's detention following detention action, if any of you still have detained clients. I'm going to assume that there's some people who aren't fully aware of unlawful detention case law and stuff. So for those of you who are, there'll be references to stuff that I'm sure you're familiar with, but I just want to make sure everyone's following. So to start with, the general problem with detaining people during a pandemic. And this is referred, the best place to start with these are I've put on the side the two Professor Coker reports, who's an expert in pandemic control, and why it's such an issue to hold people in detention whilst there is a pandemic going on. Obviously, you're holding people in a very confined space. You have multi-person rooms, shared toilets. There's a whole range of evidence that points to overcrowding within detention. People are obviously coming in and out of detention, not only visitors, but obviously there's people coming into detention, then being transferred to a different detention centre. There's obviously staff coming in and out all the time, so mixing with the general population and then going into detention. There's obviously issues regarding sanitation. So there's a lot of evidence about the unsanitary conditions which people are being held in detention. The detainees themselves often are doing most of the cleaning, so there's no professional cleaning of the areas. And there's general poor hygiene and general access to ventilation. So a lot of rooms don't have windows, and generally a lack of outdoor space. So you have a whole group of people who've come from throughout the world being held together in quite a confined space. The best example on cleaning I've referenced in the report is the Lampard review, which was actually carried out for G4S. But Kate Lampard in that report said the standard of cleaning was completely unacceptable. The cleaning of wings was particularly poor. Detainees were not given adequate cleaning products and cloths, and they were generally just given some detergent, some old rags, and told to get on with it. So when we were preparing the detention action litigation, we instructed Professor Coker to do an expert report on the risks of detaining people and what would result from that. And he said that an unfolding COVID pandemic in a detention centre would, in a grim sense, represent a natural experiment. Overcrowding, unsanitary conditions, poor ventilation in a detention centre would likely increase the speed with which an epidemic unfolded, even if the number of cases cumulatively remained unchanged. He said detention centres like prisons would be an epidemiological pump. So he compared it to the issues you've had on cruises, cruise ships, and obviously a similar issue you're going to have in prisons, where you confine people to a small space. And then once the virus enters that space, especially if there's overcrowding, people aren't able to go out. So it stays within it, but it spreads very quickly. And especially spreads because of the conditions. And the context, I think when we started doing the case, it was pre-lockdown, but there was obviously growing concern about COVID within the general community. And there was very unclear guidance on what should be done for detainees. It just wasn't being talked about. And indeed, the initial government guidance from after our first pre-action letter said that basically they were handling it. Those with symptoms would just be taken away to the medical wing, so to separate them off, and then they would be able to treat them there. And they were still allowing visitors to come in and out. They were still accepting new detentions. So they were still bringing new people in. They were then obviously people would then mix, and then they were then releasing some of those people to the community or keeping some of those people inside. And there seemed to be no process for identifying people who would be particularly vulnerable. So obviously the government guidance of that failed to consider that you can obviously have the disease without showing the symptoms. So you can have the disease within your system for a few days. You can then pass it on to anyone you have close contact with, which could be 20, 30, 40 people within a crowded detention centre. And you would then show symptoms, but it would be too late. You would have already passed it on to people. So even, and they also, Professor Coker also said that quarantining people, which would be keeping people in a certain area if they had symptoms, would then obviously accelerate within that area. You would have obviously doctors coming in, maybe a lack of PPE as we've seen. And he recommended generally that unnecessary detention should be relaxed, and that it was credible and plausible that up to 60% of detainees could get COVID if they weren't released. And there's obviously a further issue as well, which is Obviously, you've seen the global flight restrictions. So certain countries have closed their borders. Certain countries are not accepting flights from the UK. Raised a serious question as to whether deportation is even possible in these circumstances, and therefore whether detention, which is an administrative procedure for facilitating deportation, whether that is even possible itself. So we then issued, Duncan Lewis issued the case on behalf of Detention Action. And as interim relief, we basically said the issues were very stark. They raised issues of Article 2 and Article 3 rights under the European Convention. And we sought the release of anyone with COVID symptoms and an urgent review of everyone's detention within a short time frame as to whether they were actually removable practically anyway. And we sought the release, later on, we sought the release of anyone from countries which the Home Office was not accepting new detentions from unless there was a high risk of harm. And this was because the Home Office, during that case, admitted that they had a list of countries with which they were not accepting new detentions from. And then because of the travel advice and the changing situation, and they were only accepting new detainees from those countries if they were high risk of harm. So probably coming from a criminal sentence and having a serious criminal conviction, so they could work out how to safely release them into the community if possible. And you'll see I've attached the judgment. Interim relief was refused. It was quite a harsh judgment from the divisional court. But as I show, I think throughout the case and even in that judgment, you can show that actually Detention Action achieved quite a lot through that litigation. It was actually, I would say, a very successful failure. And there were some clear benefits which you can point to in cases and which Detention Action can point to as a genuine achievement for achieving them. Firstly, the Home Office agreed that the adults at risk policy applied to anyone in a Public Health England risk group for COVID. So that would be the over 70s, anyone with chronic respiratory diseases, including asthma, chronic heart disease, chronic kidney disease, liver disease, neurological disease, diabetes, weakened immune system, anyone seriously overweight, and anyone pregnant. And based on this, and based on the Public Health England guidance, my view is that anyone in those categories in detention should be viewed as an adult at risk level 3, based on Professor Coker's evidence of the potential impact of being in a detained environment, and because they're accepted to be in an at-risk category who should be self-isolating or at least have very minimal contact with anyone at the moment. And I would highlight in particular asthma and diabetes as conditions that often you would not normally notice it before would have led to someone being viewed as a vulnerable individual. But in these circumstances, because of the risk within detention, asthma and diabetes are potentially really serious risks to people being in detention, and something it's worth looking out for. The Home Office also agreed that a number of countries you couldn't presently remove to, and therefore no new detention should take place. The Home Office agreed to review the detention of every individual under the Hardy-Singh principles, to simplify anyone who cannot be removed within a reasonable period by the Home Office should not lawfully be detained, including prioritising the most vulnerable, and then throughout the whole week's reviewing the detention of everyone. That seems to have taken place, though the quality of those reviews is questionable. And the Home Office also agreed to improve cleaning procedures and the access of information for detainees so they would know if they were at high risk and what they should do. So that's a particular issue. Detainees they obviously have access to TV, they see the news, they see that there's this big issue going on in society. They feel like they're at risk, they're not being able to self-isolate. The government guidance on the lockdown came in. They can see what's happening outside of detention, but they don't know what's happening in detention. And they weren't being advised in a language they can understand whether they were in a high-risk group and whether they should be socially distancing from other people. So those were clear commitments that are referred to in the judgment, and anyone with an ongoing detention case can refer to those commitments from the Home Office. And if in your individual case, the Home Office haven't followed any of those principles, then you should be raising that with the Home Office. I would also, the reduced numbers of people in detention. So the Home Office have generally said in January there was 1,200 people in immigration removal centres. We then did a pre-action letter. By the time of the hearing in the Divisional Court, there were only 736 people in immigration detention. And then by the 21st of April, I think is the last data I've seen, there was only 368 people detained in a removal centre. And it's ours and Detention Action's view that the Home Office started to release people very quickly, especially once we started our litigation, and that people would not have been released as quickly were it not for our case. The Divisional Court didn't accept that, but I think the evidence will eventually show when all the data comes that was the position. And obviously that's good for each individual person who's been released. They can then go out in the community, self-isolate if required. But also it's important to say that it also helps those in detention because they're able to more easily self-isolate if there's less people there. There's more ability to be in single-person rooms, single-use toilets, though that remains an ongoing issue. The less people there are in detention, the safer it is for the people in detention themselves. So all those documents should be in the thing. I just wanted to point out, for those of you who do have clients in detention, either in immigration removal centres or in prisons, because the number in prisons is still, I think, around the same as the number in immigration removal centres, people who are detained under immigration powers after the conclusion of their sentence. I just wanted to point to a few tips from the case as to what you might want to do and how you might want to challenge immigration detention. The first point that I'd make is, for all detained clients, you need to see whether the Home Office themselves are accepting new detentions for those nationalities. There are some big countries where a lot of deportations happen that the Home Office were accepting that they couldn't presently remove. Now, obviously, the position is quite fluid. It changes all the time. But Jamaica, India, Pakistan, Afghanistan, Iraq, Sudan, Albania, these are countries that are in the top 10 of countries where the Home Office deport to and carry out deportation. So I would check that. Also worth checking the Foreign Office website for flight information, and a really useful resource is the IATA, I think it's the International Air Traffic Association. They have a country by country update for the latest information on flights. I think they updated their Jamaica flight information the other day, so Jamaica aren't accepting any flights from the UK at the moment. So that's a useful resource to point to stuff. Medical evidence, especially if you have a client, look at the medical records. They might not have felt it was necessary to disclose they had asthma, or they had an inhaler, or they have diabetes. But those medical reports can show that they're a really serious, vulnerable adult in detention. And then a professional medical report supporting that should be enough, in my view, for a level 3 adult at risk. And as for those of you know, the level 3 adult at risk is the highest level of adult at risk. And then individuals should only be detained if removal is set either for the immediate future or if there's significant public protection concerns, such as a 4+ year sentence. And even then, you obviously have to apply the Hardy-Singh principles as to whether a reasonable period is likely for deportation to take place. Rely on what the Home Office said in detention action. Have they reviewed their detention? Have they accepted that an individual falls under the adult risk policy? Have they even worked out that your client is vulnerable? Have they taken the steps to investigate whether someone is a potential in a high-risk COVID group? You can rely on the Professor Coker reports. They're publicly available. They're in the link, but they're publicly available on the Detention Action website. And they show the risk. And also, just to touch on it, obviously, a lot of the detainees who remain are going to be those with a criminal history. So a foreign national offender, potentially, who the Home Office are looking to deport. And then you're potentially going to have issues of a release address and whether that can be approved and whether it's a suitable release address. My view is there's a strong argument, and we've seen this in other cases, that even if they don't have an outstanding claim, or an outstanding asylum claim that would normally get them eligible for Home Office accommodation, Section 4.2 accommodation should be available, because on the basis that they cannot leave the UK due to ongoing travel restrictions, and that's one of the criteria in Section 4.2. So it's definitely worth checking that. And yeah, I think that's all I was going to mention. Obviously, I'm sure my details are available. If you have anything in an individual case and you want to try and get any information about countries and where they're on the Home Office position on return, then please feel free to email me or let me know if you have any questions after this. But I think that's all I was going to say on that. So thank you for listening.
Phil, that's excellent. Thank you for that. Really important case. Obviously grateful to have your insight into it. And no doubt those tips that you've given at the end are really going to help other lawyers with clients in the same position. You've shared the judgment, haven't you? So I recommend people read that in full.
The judgment should be in the chat link with some of those reports.
Working, but if anyone isn't able to access it, just let us know. But it's really worth a read in full. Phil, I think you're staying with us, so there may be some questions at the end if you're okay to just wait for the rest of the talk.
Yeah, that's fine, yeah.
Excellent, thank you. Okay, so I'm going to move on to our second speaker, Ali Bandegani from Garden Court Chambers, a barrister called in 2009 and ranked in the Legal 500. He's an expert on all areas of immigration law relating to international protection, and he advises clients and represents them on issues varying from deportation and to human rights and asylum appeals before the tribunal, the upper tribunal and the Court of Appeal. Ali, can you hear me okay?
Yes, thanks. Thanks, Sam.
Ali, we're going to hear from you on socio-economic rights and how COVID's impacted on that.
Yeah, thank you. Okay, I'm going to talk to you in as much detail as time permits about the economic and social rights of asylum seekers, specifically in relation to access to work and welfare support in the context of COVID-19. I hope to have enough time to go into a useful degree of detail, but if I don't, we can pick it up during the Q&A session after the talks. Just by way of introduction to this topic, I'd like to ask you to think about the idea of the structures that we're looking at, and to think about the idea that these structures don't accidentally lead to the impoverishment and marginalization of people seeking asylum, but that to the contrary, marginalization and impoverishment are built into the policy structure, and it is their purpose, as it is thought to decrease or remove the economic pull factors, that is, the financial rewards that are said to accrue, or the enticements which pull bogus asylum seekers to the UK. So the issues I'm going to explore, I'd like you to bear that in mind and perhaps see the discussion through that lens. The first then specific issue I want to discuss is, do asylum applicants have the right to work? The basic position is that those who claim asylum in the UK are not normally allowed to work whilst their claim is being considered. In law, there is no positive concrete right to work or to have a job. There is only a conditioned right to access the job market. And so what this group have instead is accommodation and support to meet their essential living needs. The financial sum is about £37.75, I think, for an individual asylum seeker, if they would otherwise be destitute. And this is provided under Section 95 of the Immigration and Asylum Act. So the only way that you can access the job market as an asylum seeker is by making an application for the Secretary of State to exercise her statutory discretionary power to work, and to make that application in accordance with paragraph 360 of the immigration rules. There's also a published policy, a work policy, which you can read alongside that, and I'll try and put that into the chat now so you can have a look at it if you want. So the rules and the policy read together mean that a person can only secure permission to work if, under the immigration rules, if two conditions are satisfied. Firstly, that the claim, the asylum claim, has been pending for a period of 12 months. And secondly, that the 12-month delay is not the fault of the asylum applicant. I should say at this point, I've never come across a client who has wanted, let alone actively tried, to delay the processing of his asylum claim or the making of an asylum decision in his case. To the contrary, it's the Home Office who routinely delay asylum decision making and have done so for years. There's a current backlog, and that's gone on for as far back as I can remember. But that aside, even if the asylum applicant satisfies those two conditions of, I've been waiting for a decision for 12 months and the delay is not my fault, even then, people are only granted permission to work effectively in principle because they are then subject to a further limitation. They're restricted to taking jobs due to what's called the shortage occupation list. And I'll try and put that in the chat as well. Now, the shortage occupation list is a list of skilled jobs published by the Home Office and in general covers the field of art, design, technology and engineering, and includes jobs like, and I'm quoting here, skilled classical ballet dancers who meet the standard required by internationally recognized UK ballet companies. So it's quite obvious, even from a cursory look at this thing, that the vast majority of asylum applicants cannot meet the requirements of the shortage occupation list. And so the right, or the conditioned right, to access the job market becomes in effect meaningless, even where the two conditions under para 360 are met for all or most, if not all, of these this group of people, because the majority of asylum seekers do not meet the requirements, for example, of recognized UK ballet companies. So what is an asylum seeker to do? He effectively can't work. And he doesn't have, so he has heavily restricted access to the job market. He cannot access mainstream benefits, and he has to demonstrate effectively that he's destitute. So if he's destitute and he's made an asylum claim or a human rights claim, and he's currently in the asylum system, and he hasn't, and his appeal or claim hasn't been finally determined, he's entitled, as I mentioned earlier, to Section 95 support. That's essentially a modest amount of financial assistance and accommodation. An application has to be made. It's time consuming, and it requires a considerable amount of supporting evidence. I think the application falls something like 60 pages. So how much does an asylum applicant get? Well, the UK does the least it could possibly do. Asylum seekers are essentially given, I think, around £5 a day. And this figure is determined on the basis of what the poorest 10% of British citizens spend on essential living items only. And that information comes from the Refugee Action Case 2014. The reality, in the world reality for asylum seekers then receiving asylum support is that on the evidence that I've seen and by reference to my lay clients is that they're rarely able to take buses to travel around cities in which they live. They're unable to buy new clothes or even to eat sufficient food in many cases. And as a group, according to the evidence, they experience higher than average rates of infant and maternal mortality, domestic violence, mental and physical ill health. So you can see straight away, just from that overview, that what we're potentially looking at here with this system is one that is in effect designed to cause the individual harm. one of the key concepts underpinning the asylum support regime is to alleviate the pressure on the housing stock in the southeast of England. And the Secretary of State will essentially disperse a person subject to a number of exceptions which centre around physical or mental ill health, ties with family, pregnancy, and things like that. But all of that, of course, will need to be evidenced. The final thing in relation to Section 95 report, support is that the standard of accommodation and living conditions are generally extremely poor, and I'll come onto that in a moment. So one of the really pernicious features of this support regime, where you are given only 37 odd pounds a week to live on, and you are effectively denied the right to provide in a dignified way for yourself or your family through work, is that if you can't save any money. But even if you could, the Home Office would question whether you are genuinely destitute without it, which is one of the conditions of accessing Section 95 support in the first place. So one of the, in my cases, people have described struggling to feed themselves, to travel, choosing between phone credits to contact their solicitors, which raises potentially significant access to justice issues, or buying clothes. They feel dehumanized, stigmatized, and humiliated by the system that is supposed to, on the face of it, protect them. You can volunteer, but this is also in effect restricted. It has to be for a charity and it can't be akin to employment. And you'd also need to cover your expenses, which on £37 a week, that amount won't stretch that far. No one in reality will take up this option of voluntary work as a means to somehow repair their self-esteem and to make a contribution to their community if it's a toss-up between bus fare or breakfast. So people end up stuck at home ruminating on their traumatic experiences and on the status that they've been denied or that's been delayed. And the reality is, of course, that these are invariably vulnerable people in one way or another, who are the last people on earth who are going to kick up a fuss or even have the know-how to begin to change their circumstances or to secure whatever external support is available. So to round up on all that, asylum seekers don't have unrestricted access to the job market. They cannot, therefore, like the majority of poor people in the UK who are British, access the unskilled labour market. That policy ended for asylum seekers 20 years ago. And the truth is that the only positive right that the asylum seeker has in this context is the right not to be made destitute or to be subject to treatment contrary to Article 3 of the Human Rights Convention. In terms of rights, this group really has the bare minimum. So all of that then, and if I haven't explained any of that well enough, obviously there'll be questions, an opportunity to ask me about it later, but I just want to talk now about how does COVID-19 impact on all this? Because as we've seen, the asylum seeker is locked into a form of dependency on the state in a condition of social and economic poverty. They have no autonomy and they are in effect the undeserving poor. And all of that is compounded by issues arising out of COVID. And the three issues that really come to the fore, in my view, are issues around delay, the absence or failure on the part of the Secretary of State to exercise discretion, because it's the purpose of this policy, it's structured and designed to cause harm, and the fact that the issue of destitution should be, in light of COVID, made easier. The test for destitution should be made easier to satisfy. So I just want to talk about those three things as quickly as I can. Delay, first of all. So due to the COVID-19 pandemic, all substantive asylum interviews have been suspended until further notice. And this was confirmed in correspondence by Kirsten Thompson of the Asylum Operations UK VI on the 18th of March. She announced that from 19th of March, the Home Office will not be scheduling any new face-to-face interviews. So applicants must now wait for an unknown period for their applications to effectively begin through the substantive interview process, which after making the initial claim is the next major step in deciding whether someone is a refugee or not. The second issue in relation to delay is that in a statement by a Home Office spokesperson quoted in The Guardian on the 7th of May 2019, the Home Office confirmed that it abandoned its 6-month target for determining asylum decisions in the normal run of cases. So the fundamental point is that COVID has compounded the pre-existing problem of delay in the decision-making process. There are likely to be delays in the initial stages and delays in asylum appeals taking place. And we know that because the tribunal has effectively adjourned all hearings and is now seeking to actively case manage them with a view to deciding whether those decisions can be decided on the papers or through a remote hearing by telephone or on video. And that raises, of course, a whole other basket of issues, which I don't have time to go into. But the fact is that if you're a person in this impoverished state and you're being asked to wait for 12 months, more like 18 months, maybe even 2 years, you're going to end up living on £37 a week in substandard living conditions where your pre-existing trauma may be compounded and be made worse. And it's notable, perhaps, that the Home Affairs Select Committee in their report from 17th of December 2018 described the conditions which asylum seekers are being asked to live in conformity with the stay-at-home policy. They were described as degrading. So delay is a huge problem. And it makes matters considerably worse for people who are already in a very, very awful situation. Discretion. Discretion comes into play in relation to the Home Office work policy that I've circulated through the chat. The problem with it is that it doesn't contain any exception allowing caseworkers to depart from the requirement that the asylum seeker can only access jobs on the shortage occupation list. So getting a job in the local Tesco cafe or as a food delivery driver is just is not permitted. And there is nothing in the policy that allows the Secretary of State to make an exception. And in fact, the policy says in terms that applications for permission to work must be decided in accordance with the policy. And the policy says nothing about the Secretary of State being able to exercise her discretion. So it arguably is a fetter on the inherent discretion of the Secretary of State to make a favourable decision regardless of what the immigration rules say. Now that is an issue which practitioners should be looking at keenly, especially where families are involved. And that's because the Section 55 duty, as set out in this policy, effectively again fetters the statutory discretion to make decisions in the best interests of children by saying that it's highly unlikely that the Section 55 duty is going to make any difference to the decision made by the Secretary of State, which is quite shocking to see it in black and white and in such strong terms. And there are a number of claims going on in relation to that, but if you do come across it, then that's potentially a basis on which you can represent your individual client and affect further change. This is highly relevant in the COVID context, of course, because delivery workers, supermarket staff, food production processing and distribution workers are the kinds of jobs that are said to be by the government key worker roles. And so these are the kind of jobs that people dispersed into Section 95 accommodation would have ready access to in their local community. and would, if they were able to undertake the work, would obviously perform a vital public service. So in light of COVID-19 and its impact on processing times, the delay, and decision-making with regard to asylum claims, its impact on the labour market, the changes that have happened there, and who are the key workers, and the location of specific unskilled key worker vacancies, I wonder whether the Secretary of State should undertake a review of her work policy and produce something much more flexible and bespoke to the exceptional circumstances we find ourselves in, as we're constantly told by politicians. And just, if I may, on the last point, destitution, it's perhaps an obvious one. Due to the COVID-19 pandemic, it's very likely to be the case, in my view, that a much wider test should be used than the statutory definition. And I don't have time, of course, to go into all of this, but there are clearly several very strong reasons regarding vulnerability, the need to have a home, public health issues, and so on, which feed into any factual assessment of whether an individual is in fact destitute. So those are the kind of areas that I think are potentially interesting points of challenge. I hope I've explained how I think that COVID impacts on this very vulnerable group. And the evidence, just to conclude, that I've read, and there's quite a lot of it in the public domain, suggests that it's detrimental to curtail the economic rights, social and economic rights of people seeking asylum by depriving them of the right to work and forcing them to take up the right to welfare support, but then setting the rates of asylum support at such low levels that it pushes people below the poverty line. It hinders their ability to navigate the asylum process. It causes poverty and suffering, has long-term detrimental effects to the individual's ability to integrate into society, even if they do secure protection in the UK. And perhaps more importantly, is a policy that I hope I've demonstrated is designed by its purpose and in its effect to cause harm.
Ali, thank you for that. Really comprehensive. I know it's a lot to get through in a short space of time, but grateful for that. You referred to the Refugee Action case, and the link to that has been shared in the comments, and I think it's paragraph 53. But if there are any questions, I'm sure they'll be followed up at the end. So, Ali, thank you. We'll touch base with you in another 20 minutes or so.
Thank you. Cheers.
Okay, so moving please to our third and final speaker, Dr. Chelvan, I said already, from number 5, a globally recognised expert on refugee and human rights law, particularly in respect of claims based on sexual and gender identity and expression. His different stigma, shame and harm model was created in 2011, and that's a tool that's been endorsed now by the Home Office and also the UN High Commission for Refugees. He's ranked Band 1 for immigration, and he's litigated cases in the Supreme Court and in Strasbourg. Chelvan, can you hear me okay?
Yes, I can. Can you hear me?
We can hear you fine. So I'm going to hand over to you, please, because I think you've got some slides to help us with your presentation.
Absolutely. Thank you very much. Let me try. Thank you. Okay, there we are. And slideshow, start from the beginning. Okay, there we are. Great. Okay, I've got a few PowerPoint slides. I know about the time that we've got the clap for carers at 8 o'clock, so I will try and sort of summarize some of the salient points. These PowerPoint slides will be available after tonight's presentation to be distributed by YLAL. Can I first of all thank YLAL for inviting me to be part of this seminar. Now, it's quite strange actually to be at the end talking about something which is slightly different from the previous two speakers, who are very much looking on the case law and the focus in relation to the refugee, the migrant in detention, or going through the process. So what I hope to be able to summarize this evening is to how to approach the issue of COVID from a different angle, primarily through the prism in relation to how we can assist the refugee or asylum seeker in relation to the process, but also how we can assist ourselves in relation to this unstable and different, unusual times. Now, we all come to do this area of law not through accident, mostly through choice, because we have a calling, especially with publicly funded work. So we have a passion, a drive. This is a poster in 2015 in relation to my work, and this is my USP about why I am an advocate in this area. We all have our different reasons for doing this sort of work, to be the mouthpiece for those who know the words but have no voice. LGBTQ issues and rights are at the centre and core of my practice, both in refugee protection claims and immigration, as Sam indicated. And this is one of my most famous clients, Duncan, who went through the system for some 15 years before being granted refugee status, indicating the barriers and obstacles which even occurred, were in front of refugees and asylum seekers even prior to COVID. So I want to talk about three main issues: principle, policy, and practice. And what is the key principle? Well, the key principle here is, of course, knowledge is power. What we're finding in these uncertain times is that the more we're armed with the information, the tools of knowledge in relation to how we can better represent our clients, will be able to provide us the power when we go through this lockdown and stagnant time. What's the current policy of the government at the moment? Is COVID-19 is stay safe, stay at home. We're waiting to see what Boris says on Sunday in relation to a slight change, but nobody can really consider that from Monday, that all of us will be going for work. But look at those words: stay safe, stay at home. Because for our refugee clients, of course, they're not at home. They've made this journey to the UK. Definition of refugee we're all familiar with under Article 1A2, this fleeing from their home to the UK. So it's a very uncertain time, completely goes against what the policy is in relation to that issue. But the underlying claim, the reason why they're here, is in relation to the leave to remain. So we shouldn't be using this period to set down tools and do nothing. There are clear issues and clear stages we can undertake in relation to ensuring proper preparation. Because even though we are currently in lockdown and we may not even get to hearings until late summer or even later, there are steps we can take in order to represent these clients. Now, Sam talked to you about the DSSH model, which I created in 2011. This is the Credo manual, the credibility assessment. Because the unfortunate position is that a lot of our clients go to the Home Office interview totally unprepared about how to narrate, how to tell their claims. Because what we are as representatives for migrants are storytellers. We tell their stories. But what we also do is act as interpreters, to interpret their words into this foreign language we call the law. So the DSSH model is there as an example, as a positive tool in order to be able to provide the narration. So for example, if the client is from, has a confidence to be able to connect with you, not clearly through face-to-face, but if they feel the confidence to be able to connect you through Zoom, video conferences, FaceTime. For example, only this week, I had a conference with one of my clients to be able to start the narration. Because we've got this time period in order to ensure that individuals have the time to sit down and talk and think about their claim. Usually the statements which my clients are producing in relation to the claims prior to going to the Home Office interview are 20 to 40 pages long. And that's a cartoon by the Hungarian cartoonist in relation to the DSSH model you'll find in the Credo manual. Because we know what's going on here in relation to the protection claims is an issue of difference and protection. But what is arising because of COVID is that COVID in itself is giving rise to protection claims. This is an article in Pink News on the 27th of March showing that Muslim leaders in Ghana were blaming the coronavirus in transgender and lesbians in the country. And what's really interesting to note is that the Home Office SIPN on Ghana had none of this evidence, as though there was no risk to lesbians or trans people, or no COI in relation to that. So we're showing that the COVID crisis in itself, not only in the UK in relation to the impact to refugees and migrants going through the process, is in effect, through the country information, creating a separate head of claim in relation to these vulnerable individuals. So what can we do? What could be the short-term consequences? And I know we spoke about this before in various forums. Portugal herself, granted an amnesty for all migrants and asylum seekers and full citizenship rights following the COVID outbreak. This showed a clear unilateral position to ensure that all those individuals who were in the country were provided with safety. We know that they are, as an invisible population here in the UK, going through the process who are not accessing healthcare because they fear what may happen to them if they make themselves known to the authorities. So principle, policy, what can we do in practice? Well, here's a checklist. Here's a checklist with respect to the client in relation to those sort of issues, in relation to the cases which I do. I specifically asked to look at toolkits in relation to how I adopt certain methodology in relation to these clients at the moment. Creating the safe space by connecting, by FaceTime. There are all sorts of methodology which you can use at the moment which ensure that they have contact. Take this time to identify the Achilles heel in the case. We've not spoken a lot about it this evening, but there are issues with respect to the first-year tribunal and the upper tribunal regarding submissions of various written documents at this stage prior to any hearing. So identifying the Achilles heel and concentrating on this at the first stage and building the case up. And front-loading the case at this stage, and I'm sure we'll hear more about this in the next couple of days in relation to funding and the government's and the MOJ's plans and the legal aid agency's plans in relation to funding. But there's also a time to see where we can open new doors in relation to claims which we initially thought were closed. This is a Home Office SIP-in on sexual orientation and gender identity, published on the 24th of February this year. What it does have within the SIP-in is a completely new change in position in relation to the Home Office's own interpretation in relation to risk on return for LGBTs. In 2009, there was a country guidance case called AJ Afghanistan. That case held that a gay LGBT person could relocate to Kabul as long as they did not give rise to public disgrace. Of course, since that case, we had the Supreme Court case of AJ Iran in 2010. But Home Office policy, including up to January 2017, was adopt the reasoning of the 2009 country guidance case as still being applicable, and that Kabul can still be a place of safe internal relocation. In paragraph 2.4.19 of the February 2020 SIP-in, it says quite clearly that it accepts that AJ Afghanistan, once read through the prism of AJ Iran in 2010, cannot be used as indicating a safe pace of relocation to Kabul. So if any of you do have historic claims of LGBT individuals where from 2009 onwards up to this date, the Home Office refused claims on the basis of internal relocation to Kabul, then you can revisit those cases and submit fresh claims. And as we know, with the current COVID crisis, the individual does not need to go and submit the claim to Liverpool. That can be done online. Let's look at the most recent case law. These are the examples of various cases which have recently been handed down by the upper tribunal. Only a couple of days ago, AS Afghanistan country guidance case, but look at the date of it. Decided last hearing date, 14th of January 2020, prior to the Home Office change in policy, only looked at reasonableness of relocation. You have PS Iran. Keeping up to date with the case law is really helpful at the moment, especially with very helpful cases such as MH Iran in relation to church witnesses. There's some very good passages in that determination in relation to general credibility and plausibility. See paragraph 31 of that determination, where President Lane goes through the early court appeal authorities and makes it quite clear in the first reported determination for some time that if you do not consider the evidence of witnesses who come to the hearing to give evidence, that is an automatic error of law. Birch in the upper tribunal, also a very important case where it's quite clear that if you get through error of law at stage 1 in the upper tribunal, then at stage 2, the upper tribunal can take into consideration any ground. It is not restricted by the prohibition under section 85.5 of the 2002 Act and new matters. Here's some other new cases. Of course, AM Zimbabwe. Everybody looks at AM Zimbabwe as a case purely on medical treatment. But read between the lines in relation to what happens to the individual on return to the country of origin. An area which has not been explored, and I'm being instructed in a case which is currently in the upper tribunal in relation to that, is protection claims based on disability. what will be the impact of the individual in the alternative to the Article 3 medical treatment case in relation to, because of their condition, their profile, how would the surrounding society treat them? And then only a couple of days ago was the Advocate General's opinion in OA, a case on UNRWA refugees, which made quite clear that actors for protection do not include the UNRWA authority or the compelling factions of the camp. So I'm using this period really much to catch up on a lot of case law in relation to Home Office policy documents, sit down and advise and see new avenues of redress which are opening up because of these cases and new policy documents. Then what about for us? We also need to consider our own well-being. I found, for one, that it's been an actual advantage to be at home, have a better work-life balance, to be able to think about my well-being and my mental health. It's really important to be able to understand that we do sometimes not think about our own well-being and mental health, especially in relation to the case we do. And about reaching out and supporting each other in relation to this time at the moment is very important. And also speaking to members of your team, reaching out to junior members, senior members. I have junior members of the team who are even on this panel discussion, listening to this panel discussion and assisting them, because a lot of junior members are not busy at the moment. So please feel free, especially the young legal aid lawyers, to reach out to the mid-levels, the senior members of your team, and see if you can assist them in relation to various cases. Because in the end, we're all here to ensure that we're safe and have sanctuary. Thank you.